and welcome to our second in a series of virtual professional development sessions. I am Clark Mashana, Executive Director of MoASSP. Thanks for your support of our association and this new way of reaching out to principals around the state of Missouri. As a reminder, this session is being recorded and will be available 24 hours from now. We will provide a link to the presentation in an email from the MoASSP office. Like we have mentioned before, you can ask questions by going to the chat box. Doug Mertz, our program director, will be monitoring your questions. Well, no stranger to Missouri principals, EdCounsel has presented many times in person, generally at our spring conference. We appreciate their willingness to share their legal expertise as we find our way through these uncharted waters. Please welcome Duane Martin and Rachel Meystedt.
Thanks, Clark. Hopefully you're doing well, and hopefully everybody that's on board today is doing well also. We're going to talk about a number of things today that I think will be of interest to everyone. As Clark indicated, this is a two-part program. This first session, we're going to spend some time talking about general considerations, and there are some topics that we want to cover there. Everything from communications to sharing private information or confidential information about students and staff to general liability. But we're also going to spend most of our time talking about personnel. And I have one of my partners here, Rachel Meystedt, is going to share the floor with me today. And she's going to be talking about the personnel issues, and I will take the lead on general considerations. For the second part of our program, which is next week, you'll be able to hear about instruction, building operations, and whole child supports. So there's some things there that hopefully you'll be able to come back and enjoy some of that as well. I say enjoy tongue in cheek, by the way, so everybody knows we all appreciate the situation that everybody's in right now and trying to work their way through a lot of the uncertainties. And that's what we're going to spend our time talking about today. Some of the uncertainties, some of the things that we can do to try to mitigate some of the legal risks that come with those uncertainties, Clark. And all right. So what I was saying is that we have certain general considerations that we want to spend a little bit of time about with you guys on, and they include communications, planned flexibility, privacy protections, and general liability. You know, some of those things are associated with leadership as much as they are legal issues, but there's really a very strong intersection between those two at this juncture. Because we're all operating in a dynamic environment and things change constantly, and they're going to change constantly this fall, we need to kind of talk about a couple of these elements. And as I said, they're leadership issues very much as they are legal issues. Let's start with communications. And, you know, I break it down into looking at it from the point of view of internal stakeholders and external stakeholders. And we can talk about who gets grouped in each one of those categories. But really, when it comes down to it, with internal stakeholders, we're talking primarily about our staff. And how is it going to work in terms of communications with our staff? And if you manage this well, it will mitigate some legal risk. And so we want to spend a little bit of time talking about that. And for building leaders, I think probably one of the things that's a good starting point is, what is the district communications plan? You know, before COVID, we all had district communications plans, whether we knew about them or not. Now they're terribly important. How are we going to really communicate to our internal stakeholders and our external stakeholders? And most board policies make the superintendent responsible for that, developing that plan. But obviously the execution is going to come down to our building leadership in a big way. So we've got to at least know what the parameters are in our district communications plan. And if we don't have one, it should be something that you dust off, take a look at, compare it to your reopening plan, if you will. What's your reentry plan talk about in terms of communications, and make sure that we know what that is. Establish clear channels of communication for your internal stakeholders. This is really key, and I think we're going to run into some problems here because information is going to travel very quickly, especially when we have positive tests, when we have individuals who are rumored to have been exposed. maybe an individual's traveled to Sturgis this last weekend, any number of scenarios. And so we're going to have a lot of people talking about what's going on. We've got to establish clear channels of communication for our internal stakeholders, our staff members, so that we have very clear idea of how what we're going to communicate out, meaning what types of information and who do they flow to. And that ties in with the privacy protections we're going to talk about in a minute, but you've really got to have those channels lined out. What things is the school nurse going to be on? What sort of things are you going to make sure that we have certain staff members involved in? So there are all those things that you need to be really thinking very clearly about now. The third bullet there is going to be, I feel like a very critical one when it comes to our staff. We are going to have to do a job of over communicating with our staff about what the rules are. And unfortunately, we all know this, but notice of those rules, you're going to have to be talking not just about the rules at the beginning of the school year. And, you know, most of us, each school year, we talk about what's in our policies and what's in our handbooks and that sort of thing. And we spend some time orienting our staff to that at the beginning of the school year, and we call it good. That's not going to work this year, I don't think. I think we're going to have changes to the rules, if you will, as we go throughout the year, adjusting to the circumstances that we're exposed to. In order to be able to deal with staff effectively, if there is a violation of those rules, we've got to be in a position where we are communicating those rules very clearly to them. And we have a process that is consistent from one staff member to the next in how we deal with violations of those rules. And so we need to be thinking about, okay, what's that look like as we change the rules of the game, if you will, throughout the year? Unfortunately, I just think that as we go forward, we're going to have to make some adjustments. We've not been in this territory before. People are going to expect us to be operating at a much higher level than what we were this last spring. And because of that, we're going to have to do some things that make adjustments as we go. And that's going to include to our rules. And so we need to make sure we're providing clear notice to our staff members of what the rules are. And if we amend them, change them, revise them, we need to take care of that as well. We also need to be talking to our staff about what the expectations of them will be regarding the enforcement of rules. If we're talking about masks, if we're talking about social distancing, what's our plan for talking to staff members as to what they are expected to do with regard to all of these things? And there's going to be a whole host of those things that you're going to have to work through. And I think that the more groundwork that you can do up front, obviously you're not going to have all of the answers going into this year, and you're going to have to kind of explain that to the staff as well. But one of the things that you're going to want to do is talk to them about what they are expected to do when it comes to the enforcement of some of the rules that we have that we're putting in place based on COVID, and what their true expectations of them might be. You know, one thing that we have to bear in mind there is that a standard unenforced is basically a new standard. So if you have a rule in place and you're not enforcing it, basically you have a new rule. And so that's always something that to bear in mind when we start talking about this kind of thing. And we're going to have some resistance, I think, in different pockets about how we are approaching masking issues, meaning face coverings, and also social distancing and a number of other things that come into play. So clear communication of those expectations up front is going to be pretty important. Let's talk about the external stakeholders for a minute. Hopefully we've got a plan for how we're going to be able to communicate with our students. Again, clear notice of the rules and what the expectations are. I would start laying the groundwork for the idea that we're going to have to be flexible. We may have to make some changes throughout the year. What is now, if we're starting out in person, understand we may have to go to plan B. We may have to go to plan C. Not saying you go into detail with kids, but let them know that, okay, we may have to make adjustments and you're just going to have to make those adjustments with us. Same with the parents. That planned flexibility is something that we probably want to be talking to them. And if you know what some of those prominent contingencies might be and how you plan to address them, With the parents, I would go ahead and note those things as we're communicating with them up front. And then your community at large is largely going to echo what you've done with your parents, what the plan is and what the flexibility is in that plan. All right, I've mentioned flexibility several times. I want to talk about plan flexibility. And part of the reason why I think this is important to talk about in the context of a legal discussion is that when you have things that change a lot, when you have things that develop very rapidly, especially things that involve safety, they become legal issues very quickly. And so it's absolutely critical that you have some contingency planning in place on what you're going to do as certain particular scenarios that are foreseeable arrive. And you've got to be able to talk to your staff about, okay, there's a plan for that. We will deal with that. And also find out from them what kind of contingencies they have questions about so that you can kind of start thinking about those things. If you start prepping your staff now for the fact that we're going to run into some unpredictable things, and that would include generally and then also specifically related to COVID, they just need to know that that's what you're going to do up front. The reason why that mitigates risk is you have to build some trust with your staff at the beginning of this year, all in the context of not having a lot of answers and not being able to give them structure. And a lot of our staff members, they like control and they like to have structure and they like to, we all like to have those kinds of frameworks. There's going to be a limit to what you can do in terms of offering that to them this year. And so I would encourage you to start talking to them about, hey, we're going to have some things that are unpredictable. We're going to have to adjust and we're going to do that. We're going to do it together. Those are the kinds of things that kind of help mitigate some risk that staff members are going to come back after us making claims later on. And identifying the process that you're going to use for making adjustments. At least if you can't offer them a structure of what it's going to look like at the end of the day, at least offer them, okay, here's what we're going to do if that comes up. Here are the hoops that we're going to jump through to make sure that we're addressing that appropriately. All right, privacy protections. That's my third topic there on the general considerations. You really need to understand the key parameters and make sure your staff understand the key parameters. There are types of information that can be disclosed by law and policy, and that's internally and externally. When we really start talking about this, we're not talking about just student information, but we're talking about health information of staff members. What can we disclose to other staff members? What can we disclose to the public? And we've already seen a number of releases from individuals, districts, I should say, where they've had individuals who have either tested positive, been exposed, or they've had an outbreak. And so those are things that I would start studying now and seeing what what people are putting out when it comes to those types of situations. I would also make sure that I very clearly understood what our policy calls for and what the lines are. Clear lines of what's going to be released at the district level and what's going to be released at the building level, and in particular to your staff. Because once we inform the staff of something, we can plan on it probably rolling a little bit further and rippling out a little bit. So, okay, how's that all going to work and how's it going to be coordinated? How's it going to be coordinated with your health officials? All of those things I would really strongly encourage you to consider. Confidentiality and communicable diseases. One thing that I haven't seen enough of at this juncture is that, a lot of our leaders in schools right now are not that familiar with their communicable disease policy. They've been on the books pre-COVID and they've sat there and a lot of people haven't looked at them. They don't know what's in them. They don't understand that they do have provisions in there regarding confidentiality. So make sure that you look at your communicable disease policy. If you're MSBA district or have MSBA policies, that's EBB, as well as if you're MCE, that would be Regulation and Policy 2860. And there are some particular procedures that you're supposed to follow if you have an outbreak of communicable disease, if you have an individual employee or student that shows up with a communicable disease. All of those things really need to be looked at very closely at this junction. Then we also need to look at confidentiality for with virtual instruction. Make sure that we're likely to have more virtual instruction this year from our own staff. And if we have that, we need to be bearing in mind that there are confidentiality considerations that need to be taken into account. More specifically, what I would say in that regard is that if you have kiddos in a classroom and you also have kids that are online, that might be something that, what goes on in that classroom might be viewed by somebody other than just the student that's participating online, somebody else walking by, somebody else that's looking over their shoulder, whatever it may be. And you may have some FERPA issues associated with that. You may have a number of different things that are popping up on the screen as you're engaging in virtual instruction that you need to be thinking about, what are our confidentiality issues associated with that? So when we get to health information and confidentiality of health information, it comes down to, can we share information about students who have tested positive for COVID? This is one of the common questions that we've been getting. And a lot of people want to know, okay, how do we deal with this? Well, student health information is protected by FERPA. And, so FERPA functions for school in the way that HIPAA functions for healthcare providers. Strictly speaking, HIPAA is not something that generally applies to schools, although if you operate a clinic and that sort of thing, you may have that issue. But generally, FERPA is going to be our touchstone on what we can share and what we can't share. And as many of you realize, FERPA can be fairly restrictive. It prohibits districts from disclosing personally identifiable information from student records without parent consent. Health information is considered personally identifiable information. So right now we're confronting a lot of different situations where information sharing needs to occur with health departments, and there is a health or safety emergency exception that exists that would allow a limited disclosure to public health officials. And so that's something that you're going to need to be familiar with. It's in your FERPA policy. And so that would be for MSBA, that's your JO, and for MCE, you're talking about the 2400s. Those you need to be familiar with when it comes to that public health officials and public safety, health or safety emergency exception. What do our communications look like with stakeholders when we have a positive case involving students who have been exposed? We really need to be very careful about disclosing that information. The bottom line is it's like a lot of other FERPA issues. If we disclose enough information that would allow somebody to identify who that individual is, we're going to have a problem. And so that may be a privacy concern for that individual student. There may be some stigma that goes with that student because we have disclosed it to in an overly broad fashion. So make sure that we're very cognizant of that. The health department is generally going to kind of take the lead on that. And so that's something that you can, you need to be collaborating with them as you talk about who's going to be informed about a particular exposure of a student. Confidentiality of health information involves also a number of other things. One of the things that I would say is that, you need to think about what do our communications look like with stakeholders when we have a positive case involving the student or student. And when can we share specific information about individual students? Well, the Department of Ed indicates that there may be cases where it's appropriate to disclose to a limited audience. Usually it's parents of specific student. Well, the example that they give from the United States Department of Ed is that the disclosure to the parents of specific student athletes who have been very close contact with a student who has tested positive. So make sure that you're training your staff members as we're talking, each year we do training. One of the required trainings for our staff members is about confidentiality of student information. We probably need to be thinking about what health information looks like this year for us when we're doing that, okay? If a staff member tests positive as opposed to a student, what kind of information can or should we share with the health department? Really, when it's kind of interesting when it comes down to the legal aspects of it is that we talk about it here at the firm. It's students actually have by law little bit more clear protections of their privacy information than our employees do. We do have board policy that protects the privacy of student staff health information. Staff members whose information is shared, they can have a private right of action against an individual who has made the disclosure for invasion of privacy. Basically because we have policies that would prohibit an individual employee from sharing that information about the other employee. That means that if we don't follow that rule, we might have some exposure as an individual to an invasion of privacy type of claim because we disclose something in violation of our policy. So make sure your staff members understand that. And then the Sunshine Law allows for the closure of individually identifiable personnel records. So we can close those, and we do under our board policies. Okay, getting close to the end here of confidentiality of health information. What information can we share with stakeholders when a staff member tests positive? General notice, nothing specific. Ensure the staff member cannot be identified. Provide information about possible points of exposure so that that individual, the parents and the other staff members understand that they may not be under a particular safety threat. And provide the information to the health department for contact tracing, and train your staff members regarding confidentiality of employee health information. We have already had a number of issues where staff members have been disclosing private health information about other staff members. As you can imagine, that's going to be something that's going to could really spread pretty rapidly. I would say that what we need to really be thinking about is training up our staff members so that they understand that that is protected information. And if they violate those rules, that might expose them to personal liability. All right, I just want to mention general liability and the exposure to liability before we move to personnel. Student claims, and we're going to have some potentially. Really, we're going to have immunity from many of those claims. On the employee claims, you know, we get a lot of times we get the question of, okay, is that something that's workers' comp? Usually it's not going to be. In an unusual case, it might be, but typically it is not going to be something, and it's going to be something that's excluded under the work comp rules. Make sure that you follow the CDC, state and county health guidelines. You know, I mentioned the communicable disease policies, and if you look at those, there are even some differences in how they're approached with a couple of the policy services. MSBA, for example, says that, you know, as our employees are going to act in accordance with the guidelines provided by Department of Health and Senior Services and the local county or city health departments. Whereas MCE, if you look at their regulation, it says you're going to follow the guidelines from CDC. Make sure you know what your policies and regulations call for and what you're supposed to be doing. I think a general guide is that you want to be acting in accordance with what the local health officials are telling you, and always err on the side of safety. All right, with that, I'm going to turn the mouse over to Rachel. And Rachel's going to talk a little bit about leave in the first instance, but we're going to get into any and all personnel issues that you guys want to talk about.
Yeah, so as a threshold matter, I thought it would probably be helpful to kind of go through the requirements or the eligibility reasons for leave under the Families First Coronavirus Response Act, or what from here on out I'm going to be calling FFCRA, just so we kind of have this as a base as we work through the rest of the personnel questions, which are essentially scenarios of different questions that we're receiving that you may work through in your district as well. So the FFCRA created two types of leave. One is emergency paid sick leave, and then the other is expanded FMLA leave. And so with regard to emergency paid sick leave, this is sick leave that gives your employees up to 80 hours of leave over a 2-week time period for a set number of qualifying reasons. And once your employees use up their allotment of leave, they no longer have any leave under the FFCRA. And that's when we're going to kind of work through the other options for leave if we get there. But The first would be that the employee is subject to a federal, state, or local quarantine or isolation order related to COVID-19. This is going to actually be more than just a recommendation or guidelines from the federal government or your local health department. This actually needs to be some sort of order, a lot like the stay-at-home orders we were working through in the spring. The next would be that your employee has been advised by a healthcare provider to self-quarantine related to COVID-19. This could be because the person actually has COVID-19. They may have COVID-19, but they are waiting, in self-isolation to see if they come down with any symptoms, or they may be particularly vulnerable to COVID-19. So those would be your high-risk individuals, identified by the CDC as someone who might have an underlying health condition or an older employee. The next reason is that someone is experiencing COVID-19 symptoms and is seeking a medical diagnosis. The thing to note here is that it isn't enough for the employee to be experiencing COVID-19 symptoms. They also have to seek a medical diagnosis. So if you have an employee who is home, they're saying they have a cold, they've lost taste, they're coughing, that sort of thing, but they're not going to go to the doctor to see if they actually have COVID-19, then they wouldn't qualify for emergency paid sick leave under the FFCRA. The next qualifying reason is that the individual, your employee, is caring for someone who's actually subject to an order described in number 1 above, or is in self-quarantine as described in number 2. So this isn't your employee who's actually sick, but it's, they may be caring for a parent or a spouse or a child who has been ordered to quarantine or has been advised to stay home by a healthcare provider. Number 5 is that your employee is caring for his or her own child whose school or place of care is closed, or the child care provider is unavailable due to COVID-19 related reasons. This is also the only qualifying reason for emergency family medical leave. And so how these two leaves intersect is that emergency family medical leave, or the expanded family medical leave, allows employees to take up to 12 weeks of leave in order to care for a child whose school or typical place of care is closed due to COVID-19. The first 2 weeks of that leave is unpaid, but if your employee has EPSL, this emergency paid sick leave, left and they have not used it yet, they can qualify for emergency paid sick leave those first 2 weeks and be paid for those 2 weeks that are unpaid under EFMLA. And then the remainder of the up to 10 weeks would then kick in and be paid, actually. The last reason is actually something that has not come up yet, but they kind of created a catch-all in the event we may have some sort of other communicable disease that pops up, or some branch of COVID-19 that pops up. But it's if your employee is experiencing another substantially similar condition specified by the U.S. Department of Health and Human Services and a few other people. And so this one's not really typically one we need to worry about at this point, but just be aware that it's there. As a general rule with regard to pay under these two types of leave, if your employee is staying home to care for someone else with a qualifying reason, then that pay is going to be at the 2/3 regular rate. If they are staying home because they themselves are under an order or they themselves are sick, then they are going to be at their full typical pay rate during this period of leave.
So those are the provisions, the emergency paid sick leave and the expanded family medical leave. Those were added this spring, right?
Right, that's correct.
And so specifically to deal with COVID, and sunset on those?
So this new law is actually effective from April 1st, this past April, until December 31st of this year. There has been some discussion or question, I guess, whether this will be expanded past December 31st, 2020. It's likely going to depend on how things are going, if we still, you know, are experiencing COVID-19 at a high rate, and that sort of thing. So at this point, it ends December 31st. That's the last time we're going to have to offer this paid leave, but it is paid by the district. There has been some question about private employers get to have tax breaks that help make up the cost that they're expending for this leave, but unfortunately government employers that include school districts do not. And so this is just paid leave required by the government that we have to provide. And it also can't be substituted with accrued leave. And so we cannot require employees who qualify for this leave to take, qualify for emergency paid sick leave to use their accrued leave before they take this new type of leave that we're required to provide. And so if they qualify for emergency paid sick leave, we're going to use that leave up first. And then if they still need leave in some fashion at the end of that up to 80 hours of leave, then we're going to have to come back to the table and figure out what other types of leave we can provide.
So that's kind of different than FML. Usually we run those consecutively so that somebody's off on an FML and another, you know, but with this, you've got to stack them, is what you're saying.
So you stack it, this is kind of confusing. You stack it with regard to emergency paid sick leave. But if you have something in your policy that requires FMLA leave to be used concurrently with your accrued leave, then you can require that employees use accrued leave concurrently with the EFMLEA, which is only when they're staying home because they cannot work or telework because they have to care for a child or their child, actually, not any child. And so in that way, the EFMLA is going to work a lot like FMLA with regard to that one qualifying reason, except that any leave that they don't have to run concurrently with that is actually going to be paid by the district, where typically FMLA is not paid.
So what are some of the scenarios that you would see if you were a building leader? I think we've got some.
Yeah, we have quite a few.
Okay, great.
Yeah. So this one has probably been the most common one we've received so far. And as a building leader, you're probably going to be the first stop whenever an employee believes he or she just cannot come back to work when school reopens. There have been a ton of different reasons why they have this this feeling. Some of them may actually be based in medical concerns. Some just may be generally nervous. They're watching the news a lot and they're scared about what's going on and don't want to come back to work. And so our thought on this is that when you receive a call like this, the best thing to do, your first question to ask is, why do you feel this way? Just so you can get a lay of the land and determine what sort of analysis we're going to have to work through based on their reasoning. And so the first thing we would recommend looking at, or that you can look at, is that whether or not you would accommodate this employee based on their reasoning. And so if maybe they have someone at home, their husband is sick, and they're afraid they're going to take COVID-19 home with them, there may be some accommodations we can make outside of the ADA process that will make them feel safer and allow them to come to work. So maybe we are instituting some additional physical distancing or different types, you know, anything that will make them more comfortable and able to come to work and more protected in their mind. Another option.
We're not saying that they necessarily have to make those accommodations.
No,
right?
definitely not. Definitely not. And so, and if this is done and we're not doing it through a typical ADA process, the Americans with Disabilities Act, where you were doing accommodations based on someone's disability, then that could get the district in a position where it's creating a precedent for individuals who have these concerns. And you know, we're going to have to be doing this probably for a lot more people than just this one if we go down this road. And so that's kind of the thing to keep in mind with regard to these different types of things that we're doing outside of a legal framework. That would be the same for telework. And so there may be some positions in your district that may lend themselves more easily to working from home. So you may have a bookkeeper and that bookkeeper can do everything he or she can do at work from home using their computer. And so if that's outside of an accommodations process, then that's completely acceptable if we have the work for them and it's appropriate for them and that sort of thing. But we need to keep in mind that we're creating a precedent by allowing individuals to work from home. And as always, we can run into a lot of people are going to have lots of feelings about this. And so just things to keep in mind when you're working through that. If your employee calls and of course has a reason that would trigger that leave that we just talked about under FFCRA, we need to work through whether or not that leave would apply and if we need to place that employee on leave. And so they don't want to come back to work because they've had this cough for a while, it's not going away, and they're just scared about exposing others to this cough. Then it's possible if they stay home and then go to the doctor to figure out what exactly their cough is, that would allow them to take FFCRA leave. If your employee says he or she cannot return to work because of a medical condition, that may mean that we need to determine whether or not they're eligible or if they qualify for accommodations as someone who has a disability, and if they need accommodations because of that disability. And so that would involve obtaining or giving them likely ADA certification paperwork, having their doctor fill it out, and then working through accommodations. The first, I know this says ADA leave, but the first step would not be necessarily to consider whether or not to place them on leave. We would be doing what we kind of discussed earlier. We're going to have a meeting with them, an interactive discussion, and talk through whether or not there are accommodations that would allow them to do their work at work before we move maybe to other options, such as transferring them to a different position that may mean they're around students or other employees less than they are in their typical position, as long as it's a vacant position. We wouldn't be required to create one for them. And then the last resort would be leave under the ADA. Something to keep in mind with regard to ADA leave is that under the ADA, we're required to provide employees with reasonable accommodations. And it's possible that leave would not be reasonable. It would actually be an undue hardship because typically when we're talking about leave, especially for disability, we have an end date in mind because they are receiving treatment or, you know, they're working through, they had surgery and they're recovering and they're going to be able to come back in a certain date. And so with leave related to COVID-19, it's likely that this leave is going to be based on the fact that COVID-19 exists in some manner. And as you all know, unfortunately, we have no idea when COVID-19 is not going to be an issue any longer. And so just leave for an indeterminate period of time is probably going to be an undue hardship. Once we go through all of that or any, you know, myriad options here, accrued leave, if they don't apply for the above, it could be an option that they stay home through using their accrued leave. What we need to keep in mind is your district likely has policies where if employees take too much leave that have excessive absences, then they may be in trouble. And so if your district, you know, is interested in allowing employees to use their leave more freely than is typical, the board is probably going to have to make a decision with regard to how to treat leave during this period. And it kind of goes to what Duane was talking about. When our plans and our typical rules may change a bit, that would just be something to keep in mind.
So like on that first bullet under the analysis of telework, you know, we have somebody come in and says, I don't feel comfortable in the environment. I don't want to do this. I have anxiety. Maybe they even have some medical information or, you know, information from a healthcare provider that suggests that they do have, you know, a diagnosis of anxiety. Who knows what the situation is there, but they say, well, I want to work by telework. And we say, no, that's not reasonable for us to do in this fall. And they say, well, I did it last spring. You allowed me to work from home last spring. How's that play itself out?
I think it would create a little bit of risk, but at the same time, we can point to the fact that we were all sort of scrambling and we didn't have things in place that, you know, is unexpected. And we're trying to ensure that students have the education that they need. And everyone essentially was working from home. students and employees. And so now that we are all at work and we're trying to catch students up, we're trying to, go through the typical business of the school district. If it's not reasonable for them to telework, then I think that would be a reasonable response.
Presumably the accountability is going to be a lot different in terms of the expectations of student performance and that sort of thing this fall.
Right, yes, that's been the indication.
So, good.
Okay, so the next one, this one deals with an employee who's high risk, according to the CDC, and so she's nervous about returning due to that. And so this specific scenario is a lot like the last. We kind of mentioned it in going through each step. But for an employee who's high risk without any sort of information from them regarding a condition that might be a disability, we're kind of going through the same process as anybody else. And so would we accommodate them outside of any formal process? Probably not, but you may, and we just need to keep in mind that would set precedent. We need to look at whether FFCRA leave is appropriate. If someone is high risk because they have a health condition, it's likely that they've been in touch with their doctor, and it's possible that their doctor is recommending that they stay home. And so if that happens, we need to request the documentation that we can request, and this is a little bit odd, but if a healthcare provider recommends someone stay home for purposes of FFCRA leave, the only thing we can ask for to determine they're eligible for that leave is the doctor's name who made the recommendation. And so I know we're typically asking employees for doctor's notes in order to basically show that they need sick leave, that sort of thing. We can't go that far. They can provide us with that, but we can't necessarily ask for it. So that's something to keep in mind. If they're...
When you're talking about a high-risk individual.
When you're talking about a healthcare provider who's recommended that they stay home. Yes. Yep. So anytime anybody has that qualifying reason, what we're asking for is their doctor's name. If we then, the thing with FFCRA leave is, I'm sure you've seen, for full-time employees, that's 80 hours of leave, so 2 weeks. And 2 weeks probably isn't going to get us through the end of COVID-19. So this employee is probably still going to be nervous after those 2 weeks. And so what do we do? What we would recommend is if they are high risk due to a health condition, that could be a disability, we're going to be working through the certification process, the accommodations process, including considering health and safety accommodations, transfer, possibly leave, if that's not an undue hardship. And then once that runs out or if they're not eligible for under the ADA, we're going to be looking at whether or not we're going to allow them to use accrued leave for that reason. Okay, so then now we're going to get into the EFMLEA just a bit, and this is a new question we've gotten recently a handful of times due to the fact that districts in different parts of the state or even outside the state, if you are toward a border of our state, are running into is that you may have staff who have children who attend school in another district, and all of these districts are kind of deciding based on their current local climate when to start school. And so in this scenario, we have an employee of our district, and we are going to start 2 weeks earlier than this employee's child's school. And the child's school is delaying because of COVID-19. And so the employee needs leave to care for his children during the 2 weeks before his children's school starts. And so under the EFMLEA and EPSL, the qualifying event is that an employee needs leave to care for a child whose school or place of care has closed due to COVID-19. And so based on what we have seen out of the Department of Labor regarding this type of leave, it's very likely that this would constitute a closure, even though typically, over the summer that might not necessarily apply. But because they had a start date, they've closed for 2 weeks due to COVID-19. We're likely looking at, we think it's most protective of your district to allow them to use this EPSL or EFMLEA during those 2 weeks. And so the documentation that we're asking for in order to, you know, determine that this employee is eligible is that we need the names and ages of his children, we need the child care provider and school name, and then that employee is going to need to certify to you that no other suitable person is available to care for the child. And so if, you know, this employee's husband or wife has no job, or is working from home, that sort of thing, or grandma's available and is comfortable with keeping these kids, it's possible that they may have someone else who can watch the child. But the employee is the person, according to the Department of Labor, that gets to certify whether a suitable person is available to care for the child. And so if they're telling you no one else can watch them, then the certification is the documentation that we would use.
So we can't really second guess that assessment.
No, unfortunately not. Yeah, according to the Department of Labor. Another thing to keep in mind with regard to this leave is that an employee has to be unable to work or telework. And so if they're one of those employees that we had decided maybe we're doing a staged reopening or that sort of thing, and this employee was assigned to telework, they're not going to be able to take this leave unless they tell us, I can't do my job duties and watch, you know, if you're Duane, my 6 kids at home, because they, you know, just not possible. And so even though they may be assigned to telework, if they can't perform their job duties, then they would be eligible for this leave. Okay. So
This is kind of like my Sturgis example that I gave, right?
Yes, exactly. So we have an employee who goes to Sturgis the week before school starts. How many thousands of people?
250,000.
250,000 people
No
are
mask
hanging out.
requirements.
No masks. We've all heard about Sturgis, so power to this employee, but that's where he or she went. And so, you know, that employee's ready to come back to work on Monday, but we have seen Facebook, we know where he or she has been. So what do we do? What we would recommend is that you consult with your local health department, of course, to get their guidance and see what their thoughts might be. But we also believe you'd be completely within your rights to ask that employee to get some sort of medical documentation, whether that be a note from a doctor saying that they're low risk, that they have no symptoms, that they can come back to work, that sort of thing, a negative test, or they self-isolate for the recommended period of time, which we've seen lately has been 10 days. So we wouldn't necessarily recommend that you require a negative test or any specific one of these, but give them the options among these options, and let them kind of bring to you what they think is appropriate or do what they think is appropriate. If you're recommending self-isolation and they have not been, if they're going to the doctor to get a diagnosis, then they would qualify for EPSL, that emergency paid sick leave, the 2 weeks of time. But unless, you know, they have symptoms or that sort of thing, it's likely that we need to discuss as a district how to treat the person that we've sent home with regard to leave. And so whether that's using their accrued leave.
So if I come in from Sturgis and I say, okay, and you tell the employee, okay, you need to either have some medical documentation from the doctor that says it's okay for you to come back, basically, or you're going to have to isolate, self-isolate for 10 days. And they say, okay, well, I'm not going to the doctor. I'm just going to, you know, take the 10 days. We need to decide how we're going to treat that leave. And we can make them take their leave, right?
Yes, we can. We can also place them on administrative leave.
But we need to think about the precedent that we're setting throughout the year. I mean, basically what we're doing with those kinds of situations now, we're going to be stuck with for a while, right?
Right, exactly.
Okay.
Okay, so then we've also probably, now they've been to Sturgis, they took the weekend and tested positive for COVID-19. So what do we do now? Duane kind of went through this a little bit at the beginning, but we're going to be following the protocols that we've put in place, or that maybe the local health department has helped us put in place. to put the employee on the appropriate leave. We need to determine whether there's been an impact in our district. So was that employee experiencing symptoms and at work? Who was the student, who was he or she around during that time period? And then notify the health department and students and staff as appropriate. And so that's when we're looking at whether we can always ask them if we're notifying the health department and we want to help the health department do contact tracing, and our policy wouldn't necessarily allow us to release this information to the health department. It's likely they've already been in contact themselves, but if not, we can always ask them to what extent they're comfortable with us sharing their information. But otherwise, we need to look to policy to see what kind of information we can share, and likely that's going to be something that's not personally identifiable. So a staff member, a teacher, that sort of thing, as long as they can't be identified.
And just so you building leaders know, when you get to that second bullet, determine whether other students or staff have been exposed. And some of you may have already worked through this, but the health officials are going to want to know some information about what was the masking protocol, what were you doing in terms of social distancing, what were those, so they can kind of evaluate what that level of exposure is. So be prepared for that to come if you have this kind of thing develop.
Right, and it may change their guidance on how the district responds as a whole as well.
And we've seen that, and we've seen it also vary from county to county, right? So,
Yes.
but it does impact what their guidance is. We've had them based on masking say you don't have to close a particular building because they were masked up and that sort of thing. So they will be wanting to know those kinds of protocols that you've got in place and whether or not they've been actually followed instead of just what you have on the books, right?
Right. Okay, so now we're kind of getting away from leave and we're working more toward the health and safety protocols. And so your district has mandated masks for all staff and students due to a local health department mandate. An employee comes to work and says he refuses to wear a mask because it infringes on his rights. Can the district require he wear a mask? And so our response in this instance, especially if there's a local health department mandate, is that it's a requirement. It's a health and safety requirement, just like any other sort of health and safety requirement we might require of employees. And so, and also I'm not really sure, I guess it kind of depends on what sort of rights he's going to tell you that are being infringed upon. Generally, what we've seen a lot of times is that it's just a general statement of my rights.
And I really don't think that, you know, even if you don't have a health mandate from the county officials or whatever, if the school has made that determination, that's fine. And it's not going to infringe on any particular rights because you have a compelling interest in managing the safety issue. And if you look, there's enough guidance out there from CDC, from DESE, from others that would say that school leaders should be requiring staff members to wear masks. And so because of that, I think that there really isn't anything that is an individual interest or right that's going to trump the safety issue that's out there. So you're going to have the ability to regulate it. It's more about how you manage that particular conversation and discussion with that employee. So.
Right, exactly. Another thing that we wanted to mention with regard to this is that most mask requirements have come with a statement that says we would exempt this for medical reasons. And so, as I'm sure you're well aware, the only time we're really comfortable with obtaining medical documentation from employees is when we're working through a legally required certification process for some sort of protected leave or accommodations or that sort of thing. And so if, you know, the employee says they have a medical condition that would mean that they don't need to wear a mask, we would recommend working through the ADA process with them. It's possible that they're not going to have a disability and that they wouldn't be eligible and that sort of thing. But regardless, that's the safest process to work through when you're obtaining medical information from employees and students with regard to these mask exemptions. Okay, in this scenario, the district has not mandated masks, but they're encouraged. An employee's wife is ill and he's asking that staff and students be required to wear masks in his classroom. Should the district require masks in this teacher's classroom? So the district, this is essentially, in my opinion, a request for this employee to receive accommodations for his wife's condition that may or may not be disability or health condition, but regardless, the district under the ADA is responsible for accommodating an employee based on an employee's disability. But since this is something that is not related to the employee directly, the ADA wouldn't kick in. But this would probably be something that your district's going to want to discuss, because we're working through accommodating someone outside of the ADA process. And so if we're doing things like this, we're going to be creating precedent.
And we're not required to.
And we're not required to, yes. And so that's just something you would work through as to the level of comfortability you have with regarding what things you might allow. It may not be masking, it may be, you know, extended physical distancing, other sort of safety protocols, that sort of thing that we work through this with this employee. Outside of that, the employee, if his wife has a serious health condition and he needs to care for his wife, as allowed under the FMLA, he could qualify for protected leave under the FMLA. This would be different than the EFMLEA with regard to caring for a child. So this would just be regular FMLA that would be unpaid unless the employee used the accrued leave at the beginning, just regular typical process. Outside of that, the district could allow the employee to use accrued leave if it wanted to, but just like we discussed before, we may need board approval to do that. Or again, just kind of like the accommodations, if we could allow them to telework possibly, but this could also set precedent.
So of those that are required there, meaning that the district would be required to do those, the ADA piece, we're not required to do it because it's not our employee. FML is going to be FML, just like it was pre-COVID, and so they may qualify for FML under that, right?
Mm-hmm.
They may be entitled under our board policies to use the accrued leave that they have, right?
Right.
But the eligibility for teleworking is really not, I mean, we're going to go through the ADA analysis maybe, but it really doesn't make sense if it's a spouse.
No, it doesn't.
So you don't even really have to do that, right?
No, you don't. That's right. So most of this is going to be at the district's discretion, but for FMLA.
But the reason we mentioned it is that we've had a lot of districts that have tried to figure out where's that balance. Where are we going to make the accommodations, even though we're not required by law to do it? How far do we want to go in trying to accommodate staff members in this time that we're dealing with? And it's going to come down to, you got to have staff members.
Right.
And so, yeah, okay.
Okay, this one is going through, this time your employee is the one who has the disability, and she's saying she can't wear a mask and wants an exception to the mask mandate. And we've discussed this a little bit earlier. So this is essentially, we're gonna go through the ADA process. If we have not determined that this employee has a disability based on this specific condition, we're gonna wanna work through the ADA certification process. If we do have information that this employee has a disability due to this condition, then we're just going to want to reconvene to have that interactive discussion and modify the accommodations we have in place for this employee, and just talk through what things would work based on what she is saying that is an issue with regard to her disability. So additional physical distancing, would that work? Would a face shield instead of a mask provide as much protection? Could we transfer her position to a different position where, you know, she's not interacting with people as much? And then as a last resort, always leave. It needs to be considered, but you do not have to provide it if it's an undue hardship. Okay, so then the next is kind of looking down the road a bit, or maybe not so much. We've had some districts who've had to cancel summer school due to staff shortages because of exposure. So it's just, these things are going to come up, unfortunately. So how do we work through them? And so in this instance, we have a staff shortage due to lots of employees who are isolated and or awaiting testing. And so how can we help manage the shortage? And so DESE requested from the governor waivers of the salary and number of hours worked limits for retirees. And so that has been temporarily lifted through the end of the governor's emergency order, which is how it reads. And so right now, the end of that emergency order is the end of this year, but I mean, it could be extended. And so if it is extended, this waiver would be extended as well. But essentially, the salary limits, the 550 hours limits are lifted. And so if we need to kind of grab from our pool of retirees to help us work through some staffing shortages, that is an option available to us. And it applies to both certified and classified employees. So in this scenario, due to COVID-19 concerns, we have lots of students who are not going to be in district. And now we're thinking we have more staff, certificated and classified, than we actually need at this point. And so how can the district manage this situation? There has been lots of different thoughts on how to work through this. Leaves of absence might be an option depending on your policy, or your district might want to consider whether or not they want to create a special leave of absence for COVID-19, paid or unpaid, that sort of thing, in order to manage the staff shortage. Because, you know, if we get rid of these staff now, are we going to need them in the future, that sort of thing. Another creative thing we've heard is that due to COVID-19, it's possible that you may have lots more staff than you need, but it's also possible if you reduce that force, you're going to have instances where the force you do have might be isolated or staying home. And so something that could happen is that you hang on to a handful of teachers that act as floating teachers, so you're using them as substitutes or where you need more coverage throughout the day. And then, of course, we have reductions in force or furloughs. Reductions in force typically apply only to certificated staff because they're created in statute, but your board policy may also apply reduction in force procedures to classified staff. And so that's something to keep in mind.
See, that's something that's often overlooked, because the MCE policies actually have a reduction in force for support staff members. Now, it's not terribly onerous, I wouldn't say, but it is on the book, so you need to make sure you're consulting that if you get to a point where you're pulling custodians or other classified staff members.
Yes.
So in here, you've got reduction in force and furloughs, and we're hearing a lot about furloughs from different districts. Furloughs really isn't something that's on the books as far as Teacher Tenure Act or anything like that. It's not even a legal term or statutory term for what we do at schools, right?
Right, that's correct.
And so basically, it's kind of what you would call, I mean, it's kind of what you make it in some respects.
Exactly, yes.
Okay. So, and there isn't anything on the books, even on policy, when it comes to furloughs of classified employees, right?
No, that's correct. And so, I mean, this could be what you call, if your district makes an extended leave of absence, paid or unpaid, that could be what you call your furlough, that sort of thing. The reduction in force is going to be an involuntary unpaid leave, which essentially, to some degree, ends the employment relationship of that staff member with your district, with a right to be recalled during a period of time. However, I mean, depending on which type of employee it is and what your policy says. But during that period of time, if it's a class of, either type of staff member can actually obtain another position with another district. And so that's what a reduction in force is. The furlough, what we're hearing a lot from districts is this might be a period of unpaid leave or a layoff with a typical recall date or something of that nature. And so they're a bit different in that regard. And also, of course, resignations may be something that employees are considering. You may have employees who are close to retirement and they're like, you know what, I can't finish the year. I'm just not up for this, that sort of thing. And that may be a way, if your board is open to accepting those resignations, maybe another way to help lower the number of staff you have, your staff overage. Along those same lines, we have a teacher who comes to school and says, you know, I'm just really nervous about this year. Could be the retiree or close to retirement, and says, I just really want to resign. And so what would the considerations be in that case? And so as you're aware, that employee is going to be contractually obligated to work for the district. We're almost to mid-August. And so this is not necessarily something that would be typical. And so these are things that we need to ensure that the district and your board are on the same page about. We're probably going to need to get some direction from the board about who and or when they might be willing to accept these resignations. And if your district's even willing to entertain that sort of resignation piece. And then of course, depending on your contract and or your board policy, liquidated damages may be coming into play. And so all of these are things that need to be considered when we're deciding whether or not to accept a resignation. And ultimately that's, the board, especially with a teacher or with a teacher, that's going to be something that the board has to accept. And so that's the best way. And
they're going to have to be consistent.
Right, exactly.
This is a bit right for people to make claims about discrimination or the like. So say the board's approving those that are have physical symptoms of some sort of illness, and say, okay, yeah, you don't have, we'll go ahead and take your resignation. But the person that's claiming anxiety or some sort of mental health issue or not, that would be the kind of problem that would surface from a legal point of view. And then if you're not consistent, it makes it easier for people to make those kinds of claims throughout.
Right, exactly.
Duane or Rachel, this is Doug Mertz, and I have a question for you.
Sure.
As far as kind of back and forth with the last two slides, if a teacher, if you have a teacher, and let's just talk teachers, not classified or unclassified. So a teacher, they ask them because their numbers are down in the building, can they do a reduction in force at this point in their contract?
Yeah, and it's a great question, Doug, because we're starting to get it a lot more because people are starting to realize, either because they're having so many kids go virtual or for other reasons, that they have to consider the possibility of a reduction in force. And that typically what we do is we take care of anticipated staff reductions through the non-renewal process in the spring, and that kind of makes it much easier from a legal point of view. But the statute does have an effect, what's called an involuntary leave of absence, what we kind of refer to as RIFs, for our teachers. And it can be done at any time of the year. And even, if you think about it, your tenured teachers are under an indefinite contract. And so they can be RIFed as well. But there's a specific process in the Teacher Tenure Act that we have to follow if we're using a RIF. And, sometimes when we think of RIF, we think of it in the context of what Rachel was talking about, where, we just let them go and we don't really think about much along the lines of the recall rights. But technically, you could put them on an involuntary leave of absence for a month. You could do it for, a limited period of time, because that may come up in this context where we're dealing with COVID, and you may have a closure for a particular period of time and you do need to go ahead and do it. This last spring, we didn't do that because we did, everybody wanted to continue to pay and we were still having them, perform some work. But, there may be a limit in certain districts in the ability to financially continue to carry it in that way.
Okay.
If we do that, Doug, there is a particular process that we've got to go through. And it's important for our leaders to know that, if you do that, it's going to be your probationary teachers that get bumped first. And so you end up with this kind of whole reshuffle potentially when you do it, because if you do an involuntary leave of absence and you start to RIF a particular position, and you're really doing positions, not people, but when you RIF those positions or put them on an involuntary leave of absence, if it's a position that a tenured teacher is in, now they can take some probationary teacher's job that they have elsewhere if they are qualified for it.
Okay.
And that qualified basically means if you're certificated for it and otherwise capable of holding it, is kind of the way we look at it under the law.
Okay.
So, but there is a specific process for doing it, and it comes down to probationary teachers get bumped first. And then if it gets to be deciding between two tenured teachers, it's going to be based on their performance-based evaluations and their seniority in the field of specialization. So.
Right. A second question that came up was, and it's all the way back to the confidentiality piece. So you have a staff member, let's just take it a high school classroom to make it simple. So I'm a high school math teacher and I go home on a weekend and all of a sudden I have the symptoms, I get tested, I have COVID. And so how do they protect that teacher from being identified?
Great question. And, you know, one of the things that is important to realize is that the county health officials, the health officials that are involved, they do a lot of the notification of individuals that they believe would be potentially exposed to the point that there may have been a transmission. So a lot of that in terms of the parent notification and that sort of thing, it needs to be in collaboration with the county health officials. And so the individuals in the classroom are likely to receive notice, in particular if they've been in close contact with that particular teacher. And if we've had situations, Doug, where masking was being pretty strictly honored in summer school.
Right.
And some of the county officials said, because you were masked up, we don't need to notify all these folks. We don't need to do this and that. So so you really want to be doing something that's consistent with what the health officials are telling you in that regard. Where we've had the problem, Doug, though, is that the exposure, not so much with the students in the classroom, but the other staff members in the building.
Right.
And that sharing of that information. And really it is on a need to know basis. And, you know, do those other teachers need to know that health information about that teacher? And so we're going to have to be pretty clear about what with that individual that has tested positive, you know, who have they had contact with, and being able to kind of go through that tracing of that and then evaluate whether or not that person needs to know based on the exposure.
Okay.
That's going to be one of the toughest problems, in my opinion, Doug, because, you know, our staff members are going to want to talk and they're going to claim that we're not being safe and, you know, those sorts of things. And that's going to be something that's difficult to manage because we can invade the privacy of that individual by disclosing the information pretty quickly to people that don't know.
All right. And then a third or last question, and I know that we didn't really get into, I wanted to make sure I had some question and answer time here, but another question that came up is if you're a school in a situation where you have two different health departments or county health officials that are giving maybe recommendations or orders, and we maybe probably talk about the difference there, but let's say they have orders in two different counties. Do you take the most restrictive order and apply it if you're getting students from both sides, or do you get to make your decision or choice?
It's a great question, and it's one we've had come up on multiple times already. And actually, we've got some that are in more than two counties, and so they're ending up with just and we've got one district that has three counties and three different opinions about what the school should do from the health officials of those various counties. And so it's crazy. But to answer your question, you know, you do want to, if you have kids in buildings in each of those counties in particular, then you're going to need to pay attention to the most restrictive.
Okay.
Okay. Now, I distinguish that between the district that has buildings, you know, I'm thinking of one of the scenarios that we ran into. The buildings are all in County A, but they have student population feeding from County B. And there was a variance or difference between the two counties in terms of what the health officials were saying. And we said, go with the county where all of your kids and all of your buildings are located, meaning that's where you're serving kids. Yep. That's where, you know, all of your operations are. You know, the transportation arguably is going to, you know, not go, you know, it's going to not necessarily follow that analysis that I just gave you, but I think by and large, if you do that, you're going to be fine.
Okay. And then back to that point of recommendation versus an order.
Yeah.
So let's say I have a recommendation to wear masks, but we as a district don't feel like masks are what we want to do at school. Maybe that's not a good example, but versus an order like we have in our county or city.
Yeah, and here's where I think I'm not sure everybody kind of realizes how this might play out. In my own county, we have this issue of the health department, their health board passing a resolution that called for a requirement of masks. But it was never approved by the county commission, and there's actually a lawsuit pending against the county health board to determine whether or not they had the authority because the county commission didn't approve it. So, it kind of goes to your question about, okay, is it, does it have to be a valid order? Does it have to be a recommendation? The truth of it is, I think you've got some exposure to liability if you don't follow that recommendation. And the reason why that's the case is that, normally we would be immune, but unfortunately, some of our policies say we're going to follow the guidelines of our local health officials. So somebody's going to make the argument that, okay, it wasn't a mandate, but it was what they were recommending. It was their guideline. It was their guidance. And so, like, if I, look at, and I'm not picking on one policy service or the other, but if you look at what the communicable disease policy for MSBA EBB says, students or employees with communicable diseases that pose a risk of transmission in school or at school activities will be managed as required by law and in accordance with the guidelines provided by the Department of Health and Senior Services and local county or city health departments. So if we fail to do that, somebody's going to argue we're failing to follow our own policies.
Right.
And so that would be my concern in assessing the risk on that one, Doug.
Okay. Sorry to interrupt, but
you're going to stop asking me questions because I give you too lengthy of answers, right?
Yeah. I'm done with questions.
Duane and Rachel, we had a principal that called last week with concerns about their superintendent not following CDC recommendations. The principal's question was, is the principal protected as a whistleblower?
It's one of those things that you're really going to have to look at particular facts, Clark, and here I want to kind of talk about what some of those may be. First of all, they're really going to need to cite to where an official is violating the law or policy, specifically a rule from the district. And CDC guidelines would probably not qualify unless it is like the situation I described, where it's incorporated into your policies that you're supposed to follow those guidelines. So they're going to need to be able to point to a clear rule violation, is my point. Secondly, they're going to need to be, reporting that to an appropriate person under the statute, whistleblower statute. And that's going to need to be somebody that, you can be the public generally, but typically it's going to be somebody that is an official. It contemplates a legislator, law enforcement, that sort of thing. So it depends. The protected activity is going to depend on primarily those two things. That's what I look to first. Is it somebody reporting a violation of law or policy? And are they reporting it to somebody that would be covered by the statute?
One.
Okay.
And it relates to collective bargaining. And so we just wanted to remind districts that have unions and have agreements with employee groups that most likely the collective bargaining agreement with those groups is going to cover employee leave, possibly reductions in force, retirement, which it could mean when an employee could retire or what sorts of benefits they'll receive if they do retire, and then the right of representation in some meetings. So if we're going to have a discussion about a RIF or that sort of thing with an employee, it's possible that your collective bargaining agreement is going to give them the ability to have representation with them as outlined in your agreement, whoever that might be. So those are just things as you're working through how to address these different personnel issues. If you have a collective bargaining agreement, it would be just another one of those things to dust off in this time and take a look at and make sure that we're following.
Great advice. Duane, Rachel, excellent information. No easy answers today, is there?
There aren't, and and you and I have talked about it before, Clark, where pre-COVID, I was in the habit of saying that the hardest job in education is a secondary principal. And then we have this pandemic that's created all of these issues and uncertainty, and who does that fall to more than anybody else? It seems to me that it's our secondary principals that are the ones that are, going to be bearing the brunt of it this fall. So, we're happy to support the association in this way, and we appreciate the opportunity. But, if there are other pieces of this that you want to talk through at some point or have us provide additional information, we're happy to help. We do understand the challenge that's ahead
Today. Well, again, thank you so much, Duane, Rachel. As a reminder that our next virtual event is next Wednesday, August 19th, reopening amidst uncertainty for school principals. Once again, we'll have EdCounsel talking about instruction, building operations, and whole child support will be the focus. We hope you can join us and pass the word to your colleagues as we consider legal aspects in these uncharted waters. Have a great rest of the week.